Yes, Damini, please start.
Am I audible properly? Hello.
Yes, you are audible, Damini.
Okay. So my name is Damini Rathore, and I am here to present on the Order 16 to 17 of CPC. Order 16 of CPC deals with the procedure of summoning of witnesses. So before we move on, we could broadly see. Uh, Before we move on, we will broadly see the stages of civil suit. So the civil suit starts with a plaintiff filing a plaint against the defendant, and at the admission with the admission of such plaint, the court issues a summon against the defendant to appear, and if he appears, then he files a written statement, and if he does not appear, the court proceed with ex parte. So after a filing of written statement, the court moves on framing of issues based on the plaint and written statement of defendant, and after framing of issues, the court opens the floor for evidence recording of plaintiff and defendant and the plaintiff, as the case may be. So at the stage of evidence recording, the order 16 came into picture, and before we move on to what order 16 actually says, it is important to know what is a summon and who qualifies as a witness. The term summon is nowhere defined in CPC. However, it has been used in various sections from section 27 to 36 and order 5th and 16 of CPC, which deals with the issue of summon to defendant and witness respectively. So in ordinary language or layman's understanding, the summon is an order by a court requiring the person to against whom such summon has been issued to present in the court proceeding on the date at which therein mentioned, date and time mentioned therein. Now the next question is, who qualifies as a witness? Again, the term witness is not defined anywhere in any legislation. So and we will take a general understanding of what witness is considered in legal fraternity. So a witness is usually a person who has personally witnesses and evidence an event taking place. Section 118 to 136 of Indian Evidence Acts deals with the competence and types of witnesses, which governs both civil and criminal cases. Herein, in the order, the term witness also includes a person who is in possession of a document material to adjourn upon the matter. So, if we take an overview of Order 16, the major rules are rule 1. Major operative rules are rule 1 first, which deals with the summon to witnesses, and rule 2 to 4 deals with the expenses to be paid to the witnesses. Rule 5 specifies the contents of summons. Rule 6 to 7 talks about different forms of summon, especially the forms in which the parties personally serves the summon, and in cases where the court effect the service of summon. Rule 8 and 9 deals with how the summon will be served, and rule 4 10 to 14 are the most essential rules of order 16, which deals with failure to with the procedure, failure to comply with summon. So the rule 1 specifies that on the date of on the day date as appointed by the court, or but within the 15 days of the date of issues are settled, the party must firstly present a list of witnesses they propose to call, either to give evidence or produce documents, and obtain summons to such persons for their attendance in the court. Second, subrule 2 mandates the party desirous of obtaining summons shall file an application stating the purpose therein. So the main object of subrule 1 and 2 is to is to give notice to the opposite party of the witnesses that have been called for examination by his adversary, and it also gives opportunity to the court to examine the prominence of the purpose for which the witness is called, and this could help in avoiding the unscrupulous litigations. Herein, the unscrupulous litigations are where the parties tries to prolong the suits by producing immaterial witnesses again and again. Hence, herein the court has given the power uh, to exercise exercise some level of discretion in allowing and disallowing the application of summons. And the same has been held in Konkanda v. Pondacha versus KD Ganpati, wherein the court held that it would be a prudent exercise of discretion by the court to insist that the party filing the list of witness should briefly indicate the purpose of summoning the particular person as a witness. Now, the sub rule 3 of rule 1 state that the parties may allow to call any witness other than the listed one in the list through a summon or otherwise if sufficient cause for omission is shown. The sub rule 4 says that the summon is to be obtained within 5 days of presenting the list of witnesses. Now, the rule 1A, which was inserted in the CPC by Amendment Act of 1976, which says that subjected to provisions of rule 3 of rule 1, any party to the suit may, without applying for summon under rule 1, bring any witness to give evidence or produce documents. However, if we read the article 1A and if we read article rule 1A and rule 1 sub rule 3, we can see the similarity, but there is a difference between the two, as the rule 1 sub rule 3 and rule 1A operates in a very different spheres, as held in the Mange Ram versus Virij Mohan, where the court held that the rule 3 deals with the cases where the parties come to the court for assistance for ensuring the attendance of the for presence of the witness by summons, and wherein rule 1A, the parties himself produces the witnesses before the court. However, in both the cases, the parties need to satisfy the court that there was a sufficient cause for the omission in the list. I hope it is clear to all.
Yes, carry on.
Okay, now the court has discretionary power in the matters of summoning of witnesses at different stages. So, summarizing the rule 1, sub rule 3, rule 1A, and 7 and 14, it has been seen that the court can exercise this discretion at the stage of allowing summons application. Secondly, in allowing to call or summon the witness not listed in the list of witnesses. Thirdly, if any witness is brought before the court without applying the summon, as been discussed before in rule 1A. Lastly, rule 7 gives power to the court that it may mandate any person who is present in the court to give evidence and produce document than in his presence or power. Lastly, order 14, which is an essential order, which provides the power to the court to suo moto call witnesses that may be stranger to the suit. So, in the case of Vishwanath Rai versus Sachinand Singh, the respondent has filed a suit against the appellant against the election of appellant as a MLA of Bihar, stating that the appellant has used a corrupt practices to to get elected, and in that case various letters of Swamiji who was convincing for appellant have been found, and in that case the court has called Swamiji as a suo moto and as a court witness to check the veracity of the letters presented by the respondent. So in these ways the court uses the rules 14. So now we move on to the rule 2, which deals with the expenses of witnesses to be paid at applying summons. So before grant of summons, within the 7 days of application, the party must pay the sufficient sum that seems to court sufficient for defraying the traveling expenses and other expenses. Secondly, for expert, if any expert has been called as a witness, then the reasonable remuneration for time in giving evidence and performing any work of expert character necessary for the case must be paid by the parties at whose instant the expert has been called. The rule 3 talks about tender of expenses at witness to the witness. So the sum so paid into the court shall be tendered to the party summoned at the time of serving, and if the party is serving the summon personally, then such amount must be paid therein with the delivery of uh, the summon. Rule 4 deals with the procedure where the amount seems insufficient to the court. So if the court feels that the amount paid for the expenses are insufficient, then the court may direct further sum. And if it appears to the court that it is necessary to detain the person summoned for longer than 1 day, then such amounts shall also be paid in the court. And in case of default, the court may order such levied amount to be attached by the movable property of the person whose instant the person has been summoned, and or may discharge the person summoned without requiring him to give evidence. And lastly, it may order both the orders. Now, if we move on to rule 5 deals with the contents of summon, which says that the summon for attendance must specify with reasonable accuracy the purpose for which the person has been summoned, which may be to give evidence or produce document, or maybe for both. Also, the time at which he is required to attend, the place at which he is required to give or produce evidences, or any particular document that has been for which the person has been summoned. The rule 6 says that when the person is merely summoned to produce a document only, shall be deemed to have complied with the summon if he causes such document to be produced instead of attending personally. So this rule exempts the person from personally attending the proceeding if he is summoned merely to produce a document. Rule 7A enables the party to personally personally effect the service of summon. So the court may, on application of issue of summon, permit such party to effect the service of such summon as on such person and the delivery of summon of such party for service. So in this case, in these cases, the summon will be deemed to be delivered when the party personally delivers the copy signed by the judge or the officer of the court and sealed with the seal of court. Also, in examining whether the summon was effectively served or not, the rule 16 and 18 of order 5th will be applicable. And if the such summon when tendered is refused, or any reason such summon cannot be served personally, the court shall, on the application of party, reissue such summons to serve by the court in the same manner as the summon to the defendant. And if the party personally serves the summon, then the charges of some service of summon will not be applicable. Rule 8 deals with how the summon will be served. So every summon will be served in the same manner as as the summon to a defendant under the rule under the order 5th and the section 31 of CPC, which specifically says that the person summons to witness specify summons to the witness must be served in accordance with the section 27, 28, 29 of CPC as it did to defendant. The rule 9 says that the time of the effect of the service of someone must be done within a reasonable time, so that the party to whom it has been issued get a reasonable time for preparation and traveling to the place at which his attendance is required. So the rule 10 deals with the procedure when the witness fails to comply with the summon. So when the person who is summoned fails to comply with the summon, then firstly the court examine on the oath of serving officer or party who has effected the service to assess whether the service and the not service of summon, and where the court has reason to believe that such person has without lawful excuse failed to comply and intentionally avoided the service of someone, or intentionally avoided the service of someone, the court may issue proclamation requiring him to attend at a time and place to be named therein, and such proclamation shall be affixed on the outer door or other conspicuous part of the house in which he ordinarily resides. The rule sub rule 3 also says that with proclamation the court at its own discretion may issue a warrant either with or without bail against the such person, or may attach his property to the amount as may deem fit, as it thinks fit, and not exceeding the amount of cost of attachment or any fine which may be imposed under rule 2. So in the case of Dwarka Prasad versus Raj Kunwar Bai, the court has interpreted the order 10 and said that for issuing any proclamation, three conditions must be satisfied. First is that the witness must be a material evidence to the case. Second, that person has lawfully has no lawful excuse for failure, and or may have intentionally avoided the service. And thirdly, and if these three conditions satisfied, then under 10 the proclamation can be issued. Rule 11 said 11 deals with if the witness appears after the attachment has been done. So if the witness after the attachment of his property appears before the court and satisfied the court that he did not with lawful excuse fails to comply with the summon or intentionally avoided the service, and he had satisfy the court that he had no notice of such proclamation in the time to attend, the court shall withdraw such order of attachment. Rule 12 is also essential rule of order 16, which deals with the procedure if witness fails to appear. So where the person summoned fails to appear or fails to satisfy the court of his lawful excuse even after the proclamation or the proceedings, the court may impose upon him fine of 500 of fine not exceeding 500 rupees, having regard to his conditions of life and all circumstances of case, or may order his property or any part of thereof to be attached and sold if already been attached, then be sold to satisfy all the cost of attachment and the fine. And there is no bar that only after the proclamation that rule 12 will be applicable. At any point the person summoned fails to comply with, the court may impose the fine under subclause 1 of this rule. However, giving notice to such person to showcase why the fine should not be imposed. When the party fails to comply with the summon, the court has discretionary power to either issue an proclamation with or without warrant for his arrest, or may attach his property to recover penalties or other expenses, and impose fines, or order him to furnish security for his appearance. In default, uh, committed can be present in a civil prison. So, in the case of National Rice and Dal Mills versus Food Corporation of India, the court held that uh, it is a duty of the court to enforce the attendance of witness and the summoned by the parties, and if necessary, by the coercive measures such as proclamation or arrest or imposing fines. So exception to certain witnesses, the CPC provides certain exemption to certain witnesses from personally attending the proceedings. So section 132 provides exemption to the women who are according to custom and manner of the country ought not to be compelled in the public. Section 33 provide exemption to the person holding constitutional posts such as vice president, president of India, Supreme Court ministers, union ministers, and the speaker of both the houses. Lastly, the court has discretion to exempt from attendance as witness any person who, in the opinion of the court, is unable to attend due to sickness or infirmity under order 2 rule 1 of CPC, and who, being a military officer or government official, who cannot attend without detriment to public service under order 26 rule 4 of CPC. So these persons have been exempted being from personally attending the proceedings, and the court may issue commission of examination of witness whose attendance cannot be for such persons. Lastly, the rule 13 to 21 are not that essential, but the plain reading only provides the idea that rule 13 deals with the modes of attachment of the property, which says that any attachment and sale under this order is for if the person who is attached were a judgment, the person whose property is so attached were a judgment debtor. Judgment debtor herein is a person who is liable to pay a debt or damages to a judgment creditor by a judgment. Rule 15 talks about the duty of a person summoned to give evidence or produce document. Order 16 deals with a person so summoned and attending shall, unless the court otherwise direct, attend each hearing until suit has been disposed of. The court may require any person so summoned to furnish security to attend at the next and other hearing, or until the suit is disposed of, and in default of his furnishing such security, may order him to detain in the civil prison. Rule 17 says that the provision of Rule 10 and 13 shall be applicable to any person who having attended in compliance with the summon departs without lawful excuse in contravention with Order 16. Rule Rule 18 deals with when any person is where any person is arrested under warrant cannot, owing to absence of the parties, give evidence or produce document which he for which he has been summoned. The court may give him a reasonable bail or other security for his appearance at such time as it thinks fit, and on such bail security being given may release him in default, and in default of his giving such bail security may order him to be detained in civil prison. When Rule 20 says where the party to the suit present in the court refuses without lawful excuse to give and produce any document then and there in the possession or power, the court may pronounce judgment against him and make such order in relation to the suit as it thinks fit. Rule 21 deals with where the party to a suit present in the court refuses without lawful excuse when required by the court to give evidence and or to produce any document then and there in the possession of power. Rule 19 says that the no witness can be ordered to attend until he resides within the local limits of court's original jurisdiction, or who is not more than 200 miles if there is a railway communication or public conveyance or for 5/6 of the total distance, and provided that if where the witness lives beyond 200 miles, then and air transport is available, then the witness may be ordered to attend and the fare will be paid by the parties at whose instant the person is being summoned. Now we move on to the order 16A, which is an attendance of witness confined and detained in prison. This order was also inserted with the Amendment Act of 1976. So before we go on, it is important to know who is considered as a witness confined or detained in prison. So any person who is a material witness in the eyes of law and is detained under any law providing preventive detention at any place which has been declared by the state or by general special order to be subsidiary jail or reformatory or other institution of like nature, then such person is considered to be a witness confined or detained in the prison. The rule 2 provides a procedure to give summon to such person. So where it appears to the court that the person is a material evidence, is material to the suit, the court may order the officer in charge of the prison to produce such person before the court to give evidence, provided that if the distance of prison of courthouse is more than 25 kilometers, no such order can be made unless until the court is satisfied that the examination of such person on commission will not be adequate. Order 3 says that before making such order, the party must, at whose instant the person is being summoned, pay into the court sum of money as appears to the court sufficient to defray the expenses of execution of such order, including the traveling and other expenses of escort provided for witness. Rule 4 is the essential rule which provides an exemption to the rule 2, wherein it is stated that the state government may by general or special order direct certain personal classes of person shall not be removed from prison in which he or they may be confined or detained and thereupon as long as the order remain in force. The state government's special orders have a retrospective effect, which means that no order made under rule 2, whether before or after the order made by the state government, shall have effect in respect to such person. However, before giving any special order against such order against any such person, the state government must consider following factors. First is nature of offense or grounds for of confining the person, the likelihood of disturbance of public order, and thirdly the public interest. The rule 5 also provides exemptions to the rule 2, which says that if a person who is summoned by the order under rule 2 is certified by the medical officers to be unfit to remove due to sickness and infirmities, or he is under committal for trial or under remand pending trial or pending a preliminary investigation, or in the custody of a period which would expire before the expiration of the time required for complying with the order, or for and for taking him back to the prison in which he is confined. Or lastly, the person whom against whom the special order of state government has been given under rule 4. The officer in charge in such cases are not need not to comply with the order of someone. Order 6 deals with the prisoner to be brought in the court custody, which says that the person, any prisoner who has been summoned, must be shifted from the prison to the court custody or kept in the custody in or near the court until he has been examined, or until the court authorizes him to take back to the prison in which he is confined. Rule 7, the last rule under 16A, deals with the power to issue commission for examination of witnesses in prison. So where it appears to the court that the attendance of person could be secured under the provision of this order, the court may issue commission for examination of person in prison in which he is confined or detained. And the provision of order 26 shall be apply in relation to the examination on commission of such person in prison as they may apply in relation to the examination on commission of any other person. Sorry. Now we move on to the order 17, which is adjournment. So again, the term adjournment is not defined anywhere in the CPC, but in ordinary sense, the adjournment is means to put the matter for another time or day, or put off or postpone on the proceedings of the court to the next date. The rule 1 of order 17 says that the court may, if sufficient causes shown at any stage of the suit, grant time to parties or any one of them, and may from time to time adjourn the order the adjournment of the hearing of the suit for the reason to be recorded, provided that no such adjournment shall be granted more than 3 times to a party during hearing of a suit. So what qualifies as a sufficient cause? So while determining determining whether the grounds provided by the party is a sufficient cause or not, the court firstly will look into whether the whether the ground provided is factually correct or not, and if it is correct, then whether it is sufficient to grant adjournment or not. So in the case of Hazi Abdul Hafiz versus Nasir Khan, the court held that what is a sufficient cause of what is sufficient cause is a question of fact to be decided while considering the fact and circumstances of each cases. There are some circumstances which are being held to be constitute as a sufficient cause, is the sickness of party, his witness or counsel, or any circumstances which are outside the control of the party, or where the summon has not been served properly, or reasonable time for preparation of the case has not been given to the party, or withdrawal or appearance by a counsel at the last moment, or inability of counsel to conduct the case. So if we analyze all the causes, the main reasoning behind all considering the factors is that the circumstances that has been claimed to be a sufficient cause must be out of the control of the party. Now, modus operandi, how this rule works. So firstly, the party needs to file an application before the court, and and adjournment is not a matter of right, but it is a matter of discretion, which means the court may allow or may not allow the application of adjournment. So it is a mandate, it is a legislative mandate for a court to record the reasons for adjournment and impose as high as it may deem fit for as high cost as it may deem fit for adjournment. Secondly, the court cannot grant adjournment to the same party for more than thrice, which means that in total 6 adjournment can be given. But however, in the case of the Supreme Court in one cases has held that in exceptional circumstances the court may grant adjournment more than 6 times. However, the circumstances must be exceptional. So the court has the court cannot on its own accord or suo motu adjourn the matter. It must be on the application of parties, and also the constitutionality of the limitation of three adjournments were challenged in the case of Salim Advocate Bar Association versus Union of India, wherein the court expressed their view of not holding